Hey there, this is Tulsa criminal defense attorney Stephen Cale. I'm going to talk to you today about plea deal or plea bargaining basics. And I'm going to give you just kind of an overview of that, to give you a general understanding about what plea bargaining is all about. So let's go ahead and dive into that. There are hundreds upon hundreds of charges filed every day throughout the U.S. and in Oklahoma as well. I'm sure there's at least 100 charges filed every day in Oklahoma, but hardly any of those charges ever go to trial. Probably only about 3% actually go to trial. And so what happens to the rest of the 97%? Well, sometimes charges will be dismissed either on the prosecution or the DA's office on motion. Sometimes charges will get dismissed after there's been some pre-trial motions filed. I've had some success at getting charges dismissed because I filed what's called a demur and motion to dismiss. That happens sometimes, but again, only about 3% of the cases actually go to trial. So if the case hasn't been dismissed, then you're looking at taking care of the charges through plea bargaining. That's how almost all of the cases that are filed get resolved, through some kind of plea bargaining. So I'm going to talk to you about that. Now, there's a couple of things that you need to know. The state or the prosecutor's office is not obligated to offer a plea deal. They can, and oftentimes they do, but sometimes they want to go to trial, and that's their right. And a client or a defendant does not have to go into plea bargaining. That client has an absolute right to go to jury trial if that's what he or she wishes to do. It's totally up to the client. And typically what happens is a prosecutor will make a recommendation, and that just means they're making a plea offer. And the client, not the attorney, is the one that can either reject or accept that. Now, of course, you want to get good legal and sound advice from an aggressive attorney to see whether or not a plea bargain is right for you. And if you decide to reject the offer, then your attorney can do some aggressive negotiating. That's what I always do. I don't always recommend accepting the first offer unless it's really, really good, and if that's what the client wants. Again, it's totally up to the client. So let's kind of go over a little bit about some ways you can accept a plea bargain. So let's just assume that the terms are right for you. So you're either going to plead guilty or no contest. Well, what do those two things mean, and how are they different? With a guilty plea, you're admitting that you committed the crime, okay? It's just a flat-out admission that you are guilty. But with a no contest, that's a little bit different, and there's an important distinction between that. A no contest plea is sometimes called a nolo contendere plea. That's just a Latin phrase that means I do not wish to contend. So why might that be important for you to plead no contest? Well, let's just say that there could be or is a pending lawsuit that stems from whatever brought about the criminal charge. Let's just say, for example's sake, that it is assault and battery. Now, assault and battery can also have civil implications. So if you want to accept the plea deal, you might want to plead no contest, because a no contest plea cannot be used against you in a civil suit. If you plead guilty to that assault and battery, that guilty plea could be used against you in a civil suit. With a no contest plea, it can't. Now, a couple of things that can happen with a plea bargain. A lot of times what happens is the state will say, well, I'll offer a deferred sentence. What does that mean? That means you're going to be put on probation. And the good thing about a deferred sentence is that at the end of the probation, the case gets dismissed and you can get the charge or the case expunged. That means sealed from the public record. So for example's sake, if the offer is a 2-year deferred sentence, then at the end of 2 years, if you haven't violated the terms of your probation, then that case will get dismissed and it will get expunged or sealed. The other possibility is a suspended sentence. Now, that's still probation, but with a suspended sentence, after you finish the terms of probation, let's say again, for example's sake, a 2-year probation, 2-year suspended sentence. At the end of that, it's not going to get dismissed. It's not an automatic expungement, and it will count as a conviction. So that's an important distinction between a deferred sentence and a suspended sentence. Now, let's talk a little bit about what happens during the course of that probation. Are there some things that you'll have to do? There are, sometimes you'll be put on DOC supervision, Department of Corrections supervision, sometimes DA supervision with the District Attorney's Office. And another thing is, let me back up just a little bit. So you have your deferred sentence, probation, suspended sentence, probation. There's also what can be called a split sentence. And that means that you're going to spend a little bit of time in either jail or prison. So for example's sake, if you got a, let's just say a 10-year sentence with all but the first 5 years suspended, that means you're going to spend 5 years in prison, and then the remaining 5 years you'll be on parole or probation. There's technically some differences, but 5 years in, 5 years out. So that's the split sentence. But going back to the terms of your probation, there'll be some conditions, and they vary depending on the charge. A lot of times with alcohol-related charges, you have to do a drug and alcohol assessment, follow the recommendations. If it's a DUI charge, you have to attend what's called a victims impact panel, and some other things, DUI, what's called DUI school. You'll have to be lawfully employed. You'll be commanded or ordered not to break any city, state, or federal laws. Sometimes you might have to do community service. Now, being on probation is good because obviously you're not in jail or prison, but there's some teeth to that probation, because if you violate any of the conditions of your probation, if you, for example, even a speeding ticket, the state could file what's called an application to accelerate if it's a deferred sentence, or an application to revoke if it's a suspended sentence. Both of those are saying that you violated some kind of terms of your probation, and they want to either accelerate your sentence or revoke your probation. Now, if that happens, definitely call an attorney. I always negotiate those things. A lot of times I'm able to keep the person from going to jail or prison again, or being revoked. So definitely want an attorney if that happens. Now, sometimes with plea negotiation, you can get a reduced charge. If, let's just say, for example's sake, it's sexual battery. Sometimes that charge, just purely for example's sake, might be reduced to simple battery or some kind of assault and battery charge rather than sexual battery. The good thing about that is, one, you're lowering the charge, and then two, it's most often a reduced sentence, which is another thing that if the evidence is really stacked against you, might be able to negotiate a reduced sentence. So you definitely want to contact an attorney to help you with that plea negotiation. Now, there's also something else called a blind plea and an offered plea. With a blind plea, you're just straight out pleading guilty. Sometimes you might plead no contest, but typically guilty. But there is not a predetermined agreement. So you're putting yourselves in the hands of a judge. Typically what happens, there'll be a pre-sentence investigation. It'll go into a lot of details of your family history, the nature of the crime, some other things. I detail that in my article that I have on my website, and I'll post on Facebook. You can look at the link within the video notes here. Very dangerous. I don't always recommend that. And then there's also what's called an offered plea. You're maintaining your innocence with an offered plea, but you're saying that the prosecution has enough evidence in the case to where a jury or a judge could find you guilty. Those are pretty much last resort if you don't want to go to trial. Those are rare circumstances with my clients. I don't, first off, recommend them. I first off recommend trying to get the charge dismissed if it's at all possible, and I work towards doing that. But as far as plea negotiations go, I don't recommend a blind plea or an offered plea unless that's pretty much your last resort and you absolutely want to agree to it. Now, I have a personal policy concerning plea bargains at my law office. One is don't accept a plea offer right after that unless it's exceptionally good. I always do what's called discovery, and that forces the state to turn over evidence that it has in the case. That includes not just the bad stuff, but favorable evidence in your case. I like to do that to see, kind of look at the strengths and weaknesses of the prosecution's case. Plus, I want you to have that information to help you make an informed decision on whether or not you should accept a plea offer and do a plea bargain. So, and again, whether or not to accept a plea offer is totally up to the client. And again, I like to do discovery so that the client can have an informed decision on whether or not to accept a plea offer. And if the client wants to go to trial, I'll do that. I'll fight hard for them at trial. So I hope that's helped you out. There's more details about all this in my article on my webpage about plea negotiation and the basics of it. I hope this has been educational for you. If you or someone you know have been charged with a crime, give me a call. I'm Tulsa criminal defense attorney Stephen Cale. Give me a call at 918-277-4800. That's 918-277-4800. Or take a look at my webpage at calelawoffice.com. That's C-A-L-E lawoffice.com. Have a lot of good information on the website there for you. Hope you enjoyed this video.